The Supreme Court of the State of Colorado is now in session. Chief Justice Coates presiding.
Thank you. Please be seated. The first case we have set for our afternoon docket is Sharrow v. People. We've got it set for a 1-hour argument. Both counsel look like you're ready. Mr. Jekyll, when you're set, go ahead and start.
Thank you. Ned Jekyll on behalf of Jeremy Sharrow, the petitioner. Your Honors, in 3 cases in the 1970s, this court considered probationers facing revocation for violating a condition that required the probationer to pay in order to comply. And in each of these cases, this court held that in order to revoke probation, the district court must first find that the probationer had the present financial ability to pay. In short, this court required a finding that the probationer's non-compliance was willful and not just caused by his or her indigence. Silcott, the first of these cases, applied it to a probationary condition requiring the probationer to pay child support. Romero applied it to a probationary condition requiring the probationer to pay attorney's fees. Strickland then applied it to a probationer's restitution obligation. Then a few years later in Bearden v. Georgia, the Supreme Court held this to be a constitutionally based principle, holding that it's a requirement of due process, the due process guarantee of fundamental fairness. So thus under Bearden, this is a substantive and not just procedural requirement of due process. The holding, or the rule in this court's 3 cases, the substantive due process requirement of Bearden, applies equally in this case, a case where, to quote the Court of Appeals, where a defendant's probation is revoked for violating conditions where he's unable to pay for rent or treatment. Now, the state's response to that is that these types of violations are just categorically not subject to this requirement of substantive due process, that categorically there is no requirement for the district court to establish ability to pay before revoking. But the state really provides no reason why that would be so, and it makes no sense for that to be a categorical distinction. Let me turn to the 2 conditions that are involved here in turn. The first one, the treatment condition. The statute involved in this is 1611.7105. That's the statute that required Mr. Sharrow to receive sex offender treatment as part of his sentence. It's a requirement of a sentence to probation, it's a requirement of sentence to prison, and anything in between as well. The statute also requires that the offender must pay for it, but only, quote, to the extent the offender is financially able to do so. So the statute, I would submit, by mandating treatment, requiring the offender to pay for it, but pay only up to his ability to pay, certainly contemplates that at some point there must be a determination of his ability to pay. But more importantly here, in revoking probation, due process, and this court's rule and the 3 cases I cited, requires it. And that is because Mr. Sharrow is not here asking for a new due process right, but simply applying the established rule and an existing requirement of due process to what it logically covers. Now, public policy isn't something that's static. The situation that we're facing here is one that's created by this modern shift in public policy to this offender-funded model of probation. And I would submit that the rules in this court's prior cases and due process must apply to this modern circumstance. The state's argument that there's a categorical distinction is kind of akin to saying, well, the Fourth Amendment doesn't apply to cell phones because it only refers to houses, papers, and effects.
Well, let me ask you, Mr. Jekyll, it does strike me as at least arguably distinct because if you've got to pay restitution or a fine, there arguably is no public safety component to that. Here, if you have a sex offender, there's more of a public safety issue. I guess I have two questions. Isn't that a legitimate distinction? And to the extent that you're arguing as a policy matter we should do something different, shouldn't that be an issue for the legislature?
Well, I would say it's not a distinction for due process purposes. I think you're quite correct that it is necessary for Mr. Sharrow to receive sex offender treatment. It's necessary for him to be in treatment. In fact, it's mandated by the statute I just cited. But the kicker is he's going to receive treatment one way or other. He's either going to receive treatment while he's on probation, or he's going to receive treatment in prison, or he's going to receive treatment when he's in community corrections. And his responsibility is to pay for that to the extent that he's financially able to do so. And if he can't, the state is going to be paying for that. So he's going to be treated one way or another. Now, the decision, as Bearden says, to release him on probation is a decision that he can be in the community subject to these certain conditions. So I think Bearden also would require in this circumstance that no alternatives exist to incarceration. And there is clearly an alternative here, and it's shown by the record itself. I mean, the record shows that at the time he's taken into custody, there's already been this exchange going on between the treatment provider and the probation officer, and the probation officer is seeking vouchers to pay for his treatment. So it's not like there's no means available to keep him on probation, to keep him safe in the community. In fact, as I talked about in the reply brief, it's actually a lower cost to the state to do it that way. And the other thing I didn't factor in the reply brief was the statute, which is he's going to receive this treatment one way or the other. So, you can't even carve that out of the equation when you figure the relative costs.
And do you see us, I guess this is why I was asking about it, isn't this a job for the legislature? Do you see us writing an opinion here that says, if we agree with you on the merits, that the alternative was that the state could pay? It feels a little bit uncomfortable to me. It feels more like a policy decision than something this court should be writing into an opinion.
Well, I don't think it is a policy decision. I think it's just what's required, I mean, not only by those holdings, but also just as a matter of substantive due process.
The policy issue would be, do we write an order that says there was an alternative to keep this man on probation, which was the state should pay for his treatment while he's on probation? That strikes me more policy than legal, and maybe I'm just being super sensitive.
Mm-hmm. Well, I think that the state has already, I think the General Assembly has already announced the policy by enacting the statute, and also by having that proviso that the offender must pay, but only up to his ability to do so. So I think the General Assembly has already expressed what the policy is here. I don't think that would represent any sort of change in the policy at this point in time.
Right. Thank you.
Like I say, I don't think I'm asking this court to establish a new due process right or a new right that's different from the rule in the cases that it's already announced. Just apply it to a circumstance, a particular circumstance that's caused by a shift in public policy to this offender-funded model.
So, Mr. Jekyll, what do you do with the fact that Judge Naves made the finding that the defendant had not done enough to secure employment? I realize that you could argue that the facts suggest otherwise, but we're stuck with that finding. So I wonder whether that factual finding by the trial court renders a lot of the legal arguments sort of moot. So help me with that.
Sure. I'd say a couple of things to that. I mean, the first is that's not the standard that this court established in Romero and Strickland, right? Because that standard requires that there's the existence of a job that is available to him, that he is qualified for, that would make the nut financially, and that he unjustifiably refuses to take. So clearly that finding is not consistent with what's required under this court's prior decisions in Strickland and Romero. But the second thing is I don't even think it complies with what would be required under Bearden. Bearden requires bona fide efforts, and I think there's a wide gap between what we're talking about here with respect to the probation officer essentially just asking offering his opinion that the effort wasn't good enough to find a job. I mean, there's absolutely no evidence that resources were available or that further efforts would have netted him a job or anything of that sort. So, and I think Bearden, contemplates not only bona fide efforts to get the resources to pay, but that those resources are available if a bona fide effort is applied to it. But then just take a look at what happened here and what the record shows.
As you're looking, could I just jump in with a point of clarification? Given that you're asking the court to recognize a due process right, are you asking the court to adopt the Bearden standard as opposed to Romero?
No, I'm not asking the court to adopt any standard other than already announced in those three cases. I mean, I think
But the Bearden test, I think, for indigency looks a little bit different, so.
it's a little different than Romero.
Right, so are you saying the court should adopt the Bearden approach?
Not necessarily. It's not clear to me from those three cases if the approach that was taken there as to the standard for ability to pay, if that is based on the state constitution or what precisely it's based on. Obviously, if it is based on the state constitution can provide greater protections than the federal constitution. And I think just the Romero standard is just somewhat more exacting than the Bearden standard. It's not different, it's consistent with what Bearden requires.
Strickland and Romero predated Bearden, right?
That's correct.
I think you were about to talk about the record here. And
Yes.
so let me ask you a question about that, and maybe I'll get you back to your argument. One of the concerns I have is that, based on my review of the record, it appears that this was the third complaint to revoke probation. And the court had twice before revoked probation for Mr. Sharrow. And each time, based on the transcripts, the judge told Mr. Sharrow, this is your last chance. You got to find a way to make this work. And then the time before this one, I think it was Judge Rafferty, who specifically said that there was a long discussion about how Mr. Sharrow didn't have the money to get a place to reside in. And even though the probation department had already paid for, I think, a month or more of residence before that complaint to revoke, Judge Rafferty ordered the probation department to authorize one additional month at a motel and made it really clear to Mr. Sharrow, you've got to get a job within that month. You've got to figure out a way to sustain yourself within that month. The probation department here not only paid for that month, but then paid for 2 additional weeks, even though that went beyond the order of the court. As I understand it, they paid for 6 weeks.
So when you're talking about Judge Rafferty, you're talking about the prior revocation, right?
Correct. Right before,
Before he's reinstated and he's out this time.
Right.
As of December 5th.
right?
Okay.
And Rafferty made it, I think, abundantly clear, this is your last chance. You're not going to get another chance. And the first judge, Judge Marshall, said the same thing. And here we are again.
Right. Right. I understand the court's frustration with that sort of scenario. Here's what I have to say about that, though. I think you are, in fact, writing on a clean slate once the state releases him again on probation. I mean, if the decision here were discretionary, if it was just a matter of, well, what should we do with you, Mr. Sharrow? Should we, we've given you these other 2 chances, you didn't make it, and it's already found a violation here. And then I don't have an argument with the court's discretion to not reimpose probation at that point. But we are writing on a clean slate here because we're talking about this time. We're talking about this time, his release on probation, what were the circumstances, and so on and so forth. And so those things don't factor in to whether or not at this time his failure to get a job, was the result of him failing to have exercise bona fide efforts towards getting a job.
I guess from what I can see from the record, this Mr. Sharrow's inability to get a job to support himself has been a running theme had been for a couple of years from the moment he got probation. Probation got revoked the first time. He got another chance. It happened again. Probation got revoked again. and then it happened yet again, and that's what this appeal stems from. And then this would take me back to the findings from Judge Naves, who in 4 different ways basically said that he had not done everything within his power to get a job. So how do we ignore that history?
Well, first you have to find, I think you have to focus on this particular release on probation, and I think you need to look at what the record shows as to what he did on this particular release in probation. And what that shows is, we've got like a 50-day period here. Well, start out with the fact that he's a convicted felon and he's a sex offender, and that 50 days is not exactly a long period of time to secure employment for someone with that status and that background once a background check happens. But in the 50 days, the plan is this, Justice Samora. The plan is he's in this hotel or motel in Aurora. It's 6 miles to Labor Ready, and the plan is for him to go to Labor Ready, which you have to get to by 5 a.m. in order to get an assignment. And I don't know how many times he does that, but we know that he did get one assignment through that particular thing. He got a job for an 8-hour shift.
Let me interject there for just a moment, because I also saw in the transcript that the judge, Judge Rafferty, authorized contact with, is it Ms. Geiger?
Yes.
He authorized her to have contact with him so that she could help him with transportation, with clothing, again, with the idea that he only had a month to get a residence and that this would be his last chance. And that was not at the request of the probation department. That was a defense counsel's request. Mm-hmm. So he wasn't all on his own in terms of looking for a job during those 6 weeks.
Right, no, but he had some success getting it. He got this one work assignment. They wouldn't keep him on once they did a background check, though. So he did work, and then he has an offer of employment, which the probation officer doesn't allow him to take. That's also from Ms. Geiger, as you know, from the record, a full-time employment as a cook in her bar and grill. The probation officer doesn't allow him to take it. So, he's got considerable obstacles put in his way as to obtaining employment.
What you just referred to, the probation officer not allowing the defendant to take that job,
Right.
Was that essentially a function of the SOMB guidelines? Because, as I recall from the record, there was an allegation that there were children who were sometimes present in that establishment, and there was also the concern about him being around alcohol. So I'm trying to recall whether the probation officer's exercise of any discretion would have really been a function of the guidelines.
Well, I don't see that the probation officer said anything about children in the establishment. I think there might have been some testimony at the hearing about it, but the probation officer didn't say that. He just said that that a sex offender shouldn't be in a place that serves alcohol.
Okay. Maybe, I thought Naves said something about, I thought Judge Naves maybe said something about children being present. Maybe I'm misremembering. I
Oh,
apologize.
I think that's correct. I think that is in the record. That is his ruling out.
So the point I'm ultimately trying to make, or I'm trying to get at, is whether this is really just the probation officer being kind of random in not allowing this person to take a job, or whether the probation officer's hands were kind of tied by the structure that applies to all such offenders.
Well, perhaps it's a reasonable, and I'm not arguing one way or the other as to whether it was a reasonable restriction or not. I don't think the ISP guidelines would have prohibited him from doing this. It just says he can't consume alcohol, he can't be a patron in a bar. It doesn't say anything about him working. And it's a bar that serves food, I guess. But, and then I just forgot the point I wanted to make about that.
I guess your point ultimately was that he was doing his level best, right?
Right. I think it goes to his bona fide efforts to obtain employment. He's got an offer of full-time employment. And, whether it's wise or whether it was in the probation officer's discretion to have him refuse it, the fact of the matter is that he went out and he got himself an offer of full-time employment. He works a shift. A lot of other testimony from the probation officer, page 100 of the transcript. He canvassed the area around the motel looking for jobs. When he had the bus pass, he looked for work around in the area of the treatment provider. Probation officer confirms he went to Workforce and applied online, and also testifies when he needed to. He did walk to places, and then, of course, he received this off of employment. So that's in just a 50-day period for a guy who is a convicted sex offender who has a felony on his record. I would suggest that that meets the definition of bona fide efforts, which require reasonable and good faith efforts. It doesn't, I think there's a big gap between even what the probation officer certainly opined, and also what Judge Naves opined about, you didn't do every single thing you possibly could to get employment.
But Judge Naves also said that he didn't make his best efforts. Do you see any difference between failure to make best efforts to get a job and bona fide efforts, failure to make bona fide efforts to get a job?
I think there's a difference. The other thing I think about that
What's the difference, you think?
the difference between doing everything you can.
No, best efforts to get a job and bona fide efforts to get a job.
Well, I don't think he said best efforts, did he?
He did. He said,
Okay.
at one point, he said that, and I
You
think,
did everything you could.
he said, and I think the clear testimony and implication from his probation officer was that he did not appear to be making the best effort that he could make to obtain employment.
Right. Well, what's the factual basis for that particular opinion? I mean, it strikes me as an opinion more than something that's supported by the record, that's supported by the factual findings. I mean, just let me give you one example, Justice Moore, which would be, I mean, he's essentially adopting the probation officer's opinion, right? And let me give you just one example of that, which is this colloquy about, well, he reported that he did not look for work on a particular weekend in December, I believe. And he reported to the probation officer that he was ill, he was throwing up, he had a migraine headache, and so on and so forth. And so he didn't go out to look for work on the weekend. The probation officer's attitude is, well, did you go to a doctor? No, I didn't go to a doctor. So, well, that's no excuse then. You have to be out there, you have to be looking out every single day. And I don't think every single day translates into bona fide efforts. I think that's over and above. I don't think you have to, when you're, vomiting and you're ill and so on and so forth, I don't think you have to go out and look for work under those circumstances to demonstrate that you're making bona fide efforts to get a job. So I know that you're troubled by the track record, but again, I think we're writing on a clean slate here. We're talking about this release on probation, what happened during this release on probation, and did he make bona fide efforts on this release? I mean, the court may have a predisposition about him, but nevertheless, the test here is whether there's an actual violation. And for an actual violation, it has to show that there are resources available to him that he didn't make bona fide efforts to get.
May I? Be finished, Justice Moore? Mr. Jekyll, what do you do with the AG's argument that, can you hear me?
Yep.
So 1611-206 allows, as we've discussed, for revocation and reinstatement. So does that help to alleviate any due process concerns? The change in the law, as I understand it, to allow for reinstatement at the discretion of the trial judge, maybe because the judge is sympathetic the first couple of times to...
The argument based on black?
Well, no, I just seem to recall that there was an argument about the statute allowing for reinstatement, and somehow that ameliorates or offsets the due process concern. Maybe I'm misremembering the argument.
Yeah, well, I think part of his argument was that this prima facie evidence, this procedural change somehow altered the standard for finding of ability to pay, which I don't think, that holds any water.
Can you stay closer to
The
the
fact that he
mic?
has discretion,
Yeah,
the
just
fact
so
that he has discretion, it's, what Bearden requires is evidence and findings. It doesn't allow the judge in his discretion to not make findings. It doesn't allow the state to not have to present evidence. I mean, it requires both of those things. So the fact that the court has, the court could find him in violation and reinstate, right? But what the court can't do is find him in violation without complying with the requirements of substantive due process, without requiring with the rule that this court has set down in that triumvirate of cases.
Could I ask a question about the triumvirate of cases? It seemed to me the significance of your situation is you're asking us to broaden the rule about inability to pay to cover things other than those that were dealt with in our earlier cases. restitution, costs, fees, child support, specific payments. And I think at one point you used the term, if inability to pay was at the root of his failure to comply, something along those lines. I guess I sort of have two questions. One is, would you be saying that the denial of probation in the first place, if it was based on the presumption that the defendant, given his situation, would be unable to pay, would similarly violate due process? And along with that, does that give you any concern that if we broaden the rule that much, the fallback may just be that people don't get granted probation if there's a question about whether they'll be able to pay?
Right, okay, so I'll take the first question first. No, I'm not saying that, and I don't think due process does require it. And I think it's based on, I think it's I don't know the Supreme Court case. The parole case is basically a hope to be released on probation. You're in a different position than once you have that liberty interest that you get once you're admitted to probation. So no, I don't think that's a problem at all. Is it going to cause any reluctance to put people on probation in the first place? I don't think so, because I think there is this additional safety valve, if you will. There's a point in time when there can be no alternative to incarceration, right? That's what Bearden says. One of the things that has to be considered, even though someone has an ability to pay, there may just be no alternative, that he can be safe in the community, and therefore incarceration would be authorized. So I think given that, the availability of that, then I don't think that,
And I guess I'm sort of looking at the flip side of that, understanding there may be some cases in which you just have to be put in incarceration. But if you have a situation, as seems to be not atypical, that a court may be inclined to release somebody on probation subject to getting treatment for various things, and if the court decides then that the guy probably won't be able to pay for it, does it give you a concern that then the court would just say, well, I'll have to incarcerate you and you can get whatever treatment the state provides?
Yeah, it gives me a concern as a person. It doesn't give me a concern necessarily constitutionally. I mean, it's a policy concern, to be sure, and the sensitivity that I think the sensitivity that we have to treat indigents with, and the foundation of our legal system of equal justice under the law and not to discriminate based on poverty and so on and so forth. It's a concern, but it is a policy concern, I think, more than a constitutional concern. So I'll reserve the rest of my time unless there are other questions.
Good afternoon, may it please the court. My name is Gabriel Olivares, attorney registration number 45336, and I represent the people in this matter. I'd like to start off with the general rule governing probation revocation hearings. If the prosecution proves a violation of a probation condition by a preponderance of the evidence, the trial court has discretion to continue or revoke probation. Nothing in Bearden affects this general rule. Bearden is not a limitation on a sentencing court's discretion. What Bearden is a grant of discretion to sentencing courts that would not otherwise have it. Bearden is a grant of discretion to sentencing courts operating under a revocation scheme where revocation is required when the trial court finds a violation of probation. And the Supreme Court in Bearden said this is impermissible. Under certain cases, a trial court must be able to consider alternatives to imprisonment before revoking probation. Under Bearden, for the violation of a specific type of condition, a sentencing court must first determine whether the violation was willful. And if the violation was not willful, all Bearden requires and all due process requires is that a trial court consider alternatives to imprisonment before revoking probation. It requires that a trial court be able to exercise discretion. But in Colorado, for any violation of any condition, regardless of whether the violation was willful or not, the trial court must consider alternatives to imprisonment before revoking probation. This is the general rule. Because as explained in Black, if a court has discretion to revoke or continue probation, as it does in Colorado, it is presumed that the court considers and rejects alternatives to imprisonment, specifically continuing probation, when it exercises discretion to revoke. So Colorado's procedure necessarily complies with Bearden in every case, including this one, because the trial court here followed that procedure. Not only was the trial court's exercise of discretion an implicit consideration of alternatives to imprisonment, but the trial court explicitly stated on page 123 of the revocation hearing transcript that it had considered alternatives. It had considered continuing probation. It had considered leniency. But it also factored in the defendant's prior failures and his conduct and the circumstances leading up to this hearing. And it found that probation was not appropriate, that the alternatives to imprisonment were not appropriate. So in following the general rule governing probation revocation hearings, the trial court accorded the defendant due process. Now, of course, there's an exception to the general rule, right? If the violation is the defendant's failure to pay court-ordered compensation to appointed counsel, probation fees, court costs, restitution, or reparations, then the defendant can assert as a defense that he was unable to make these court-ordered payments. But in creating an exhaustive list of conditions for which the exception applies, the legislature necessarily excluded all other conditions. And for these other conditions, the general rule applies.
Where do you see that? I have to push back that the legislature included all other possible considerations. This statute just deals, it's titled Monetary Payments Due Process Required. I guess I'm having trouble reading in that these are the only times we're going to consider willfulness. It seems like a great extrapolation from the case law to say what you just said.
No, it's actually in 1611-206-3.
Okay.
It's the second sentence.
Okay.
So, and the legislature in 1983 created this exception to the general rule. The general rule up until that point had been that the trial court has discretion. Now,
sure, and this one, and the second sentence says, when the alleged violation is X, those things, the court, it shall constitute prima facie evidence of a violation. Where does that exclude any other failures to pay as relevant or as potentially invoking or implicating due process?
because the first sentence is the general rule. All the prosecution has to do is prove a violation of the condition beyond a reason by a preponderance of the evidence.
And it says it's prima facie evidence, so arguably there's some kind of burden shift that happens there, and that's a whole nother issue. But you said these are the exclusive times, and I'm just trying to figure out where you get that from. I mean, I don't see anything in here that excludes this situation. at least arguably the statute doesn't address this situation where a failure to comply with a condition was due to an inability to pay.
Well, I think in amending the statute, the legislature created an exhaustive list.
Well, that's what I'm asking you. Where did you get that it's an exhaustive list of when inability to pay can be considered? That's your argument. I don't see that.
That's from a Fentel. I mean, that's how they interpreted the 1983 amendment. That this
You saw it. It says that it's an exclusive list, and that's the only time you consider it?
Not the exclusive list, but a Fentel basically says this created a defense to the general rule that all the prosecution has to do is prove the violation by a preponderance of the evidence.
All right, so I mean, what do you make of the statute? And Mr. Jekyll cited 1611.7105. It said an offender shall pay for the treatment that's required to the extent the offender is financially able to do so. Doesn't that suggest the legislature was aware that there may be situations where the offender may not be able to pay?
But the legislature didn't create an exception to revocation of probation there. And I think one of the things the defendant, in this argument, I'm a little unprepared to address this because this argument's being raised for the first time today. His defense up until really the reply brief, has been completely based on due process, not any kind of statutory requirement. And I think that would be more of a defense to whether or not he actually violated probation, whether or not he should have been terminated in the first place. He could have argued that at the revocation hearing. He could have argued that, well, the statute says I am not required to pay for treatment if I can't afford it, so they should not have terminated me. And I think that would raise an issue of whether or not the trial court can even order a treatment provider to provide free treatment. And even if it could, whether it's required to by the law or whether it should under its exercise of discretion.
Let me ask you about that. Let's assume, and I recognize there's a lot of facts and a lot of history in this case, but just to isolate the legal question, assume we don't have any of those issues there. Would it implicate due process if someone in good faith just cannot pay for the treatment? Can you revoke someone consistent with due process for failure to get treatment where the sole reason was an inability to pay?
Well, under due process and under Bearden, all the court has to do is be able to exercise its discretion. So if the court at its discretion decides that revocation is appropriate, due process has been satisfied.
So you think that, does the Bearden analysis apply in this situation, in your view?
I think the Bearden analysis has been satisfied in this situation because the court exercised its discretion. Now, if the court had said,
But I'm asking a slightly different question. You could argue that Bearden only deals with the failure to pay court cost fees, restitution, a specific requirement of paying money. I want to know whether your position is Bearden applies to this failure to pay for treatment.
If this were an automatic revocation system, I would argue that this is not a reason. And then Bearden made sure to explain in footnote 9 that its I guess exception or extra procedure of requiring discretion doesn't apply to all situations. It cited to this case Powell v. Texas, where a defendant was convicted of, I think, like DWI, and he claimed chronic drunkenness and that his conduct wasn't willful. And they said, well, it doesn't apply to all situations, but here, where the condition is failure to pay restitution or fines, that doesn't implicate the welfare or protection of society. Certainly, the conditions here do.
Okay,
I mean,
that's what I'm
the
trying to
purpose
get
of
at. So
SOISP,
you would
yes.
view that as a distinction. The question, I think Chief Justice Coates is correct. I mean, at some level, if we adopt Mr. Sharrow's position, we'd be extending the prior case law to a different setting. And my question is whether that's a distinction you're relying on.
I'm definitely not relying on that. I think it's a distinction that can be made, and it's a distinction a lot of other courts have made. Washington and Utah, Idaho. They've made that distinction based on those grounds. But I think a correct reading of Bearden shows that we don't need to create an exception to Bearden because Bearden is complied with here. Bearden says that the exercise of discretion by the trial court adequately protects the defendant's due process
All right,
rights.
so, and thanks for your patience with me. So I think the rule you would ask us, or the ruling you would want from this court, is even if willfulness could be a factor in this setting, it doesn't matter here because the willfulness just gives the court discretion and it was exercised. End of story.
And the court always has discretion. I mean, I haven't read anything. There's nothing in our revocation statute that mandates revocation. The court always has discretion to continue or revoke. And here it exercises discretion to revoke. I certainly think if the court had said something like, I don't have discretion under the law, that would be an issue, and that might implicate the due process concerns. But the court recognizes discretion.
All right, so and last question. Thank you for your patience. So the court always has discretion to consider the inability to pay even when it's treatment or whatever else it might be?
I would encourage the court to. I mean, it should consider all the facts because that's really the purpose of a revocation here, right? Is for the sentencing court to be able to consider the defendant's conduct after adjudication and determine whether the original sentence to probation was still appropriate. That's what the court said in Byrd. And that's why we have relaxed evidentiary rules. That's why we allow hearsay. We allow confessions that are taken in violation of Miranda because we want the court to be able to consider all the facts when exercising its discretion.
But I read Bearden as doing more than just giving discretion, right? Because doesn't Bearden say that you cannot revoke somebody's probation if the only reason why they can't pay court order fees or restitution or fines is because they lack the ability to do it?
No, I don't read Bearden to say that at all. I don't read Bearden to say there's ever a situation, as long as the court finds that if the court finds that the violation was not willful, as long as the court considers alternatives to imprisonment, that is enough to satisfy Bearden. Bearden does not say that it must accept those alternatives as reasonable. It only says they must consider them. I think that would be, and one of the things that the court said in Black is, what we're trying to do is get away from rigid requirements in the revocation hearings that would threaten the informal nature of revocation hearings and also interfere with the trial court's discretion. And I think the Supreme Court in Bearden was hesitant to take that extra step. It certainly could have said that if alternatives are available, then revocation is inappropriate. All it said is that if it's not willful for failure to pay restitution, then the trial court must consider alternatives. It doesn't say it has to accept those alternatives. And then going on forward in Black, in that case, the Supreme Court said we don't have to consider Bearden because under Ohio's revocation scheme, the court necessarily considers alternatives. By giving the court discretion to either continue or revoke, the trial court necessarily rejects continuing probation. And it also said it doesn't even have to make an explicit finding. That is presumed by its exercise of discretion.
Can I ask you, assuming we would agree with you about your reading of the Supreme Court cases, what about our own cases dealing with ability to pay restitution or fees or child support? Are you suggesting that those also simply say, as long as you have discretion not to revoke, it's all right for you to revoke, it's not an abuse of discretion, even if the defendant lacks the ability to pay these things?
Well, I would agree that at one point, in certain situations, restitution, child support, and attorney's fees, this court held that the sentencing court has to make a finding of willfulness before it revokes. But again, I believe those cases were superseded by the 1983 amendment, which created the exception to the general rule. Because you have to remember, Silcock came out in 1972. In 1972, we didn't have a statutory procedure governing revocation hearings. As the court even actually cited Colorado in, I think, Morrissey in one of the footnotes, listing that about 30 states had set up revocation procedure by statute, but there were still some that basically relied on judicial decisions, common law, to govern how revocation procedures worked. And the Supreme Court in Morrissey and Gagnon said they were hesitant to create a code of procedure for courts to follow in revocation hearings, but encourage courts to do that. And as this court pointed out in Lovell, in 1973, following those cases, that's when 1611-206 was created. So before then, it was really informal how revocation hearings proceeded.
And so those cases like Strickland and Romero, you think were based on a common law notion rather than a constitutional underpinning?
Yeah, so Silcock, the case it relied on was a Fourth Circuit case from the 1960s that interpreted a federal statute. So it wasn't based on due process considerations. Maybe it thought it was, but to the extent it was based on due process, I think Bearden would change that. And then this test that was derived from Romero came out of, I think, a case from the 1950s, a Colorado case, which determined how to set child support and not determine whether or not violation was willful. So I think it was trying to pull from different common law principles and principles that hadn't been yet set by the U.S. Supreme Court in determining how to go forward with revocation hearings. But once this 1983 amendment came, maybe abrogate, the word I used in my brief wasn't correct, but I think in some extent it did codify those earlier cases, right? It said in certain situations, restitution, probation fees, cost to court-appointed counsel, they're treated differently. And then Offentel said, well, they did abrogate them. They did change them because it changed from a model where the burden was on the prosecution to now where the burden to prove the defense is now on the defendant. But in other ways, it also limited them by creating these 5 specific conditions under which the defense can be asserted. And it makes sense why it would do that. Those are purely financial conditions. Unlike here, the defendant, the trial court made the finding that the conditions really had nothing to do with the defendant's ability to pay. It had nothing to do with, the conditions weren't the defendant shall pay RSA or the defendant shall pay rent to the Carriage Motel. The conditions were the defendant shall not move without permission from his probation officer. The defendant shall attend, participate, and successfully complete sex offender treatment. Those have nothing to do with the defendant's ability to pay. Now, I understand there's
They do. I mean, if there's evidence, take the hypothetical where the only reason the defendant didn't complete treatment was because he had to pay for it and he couldn't. Does that create an issue? I mean, is that a due process question? And I guess I'll float it this way. Does it create an equal protection problem when if you have money, you get to be on probation, but if you don't, you can't?
So I'll explain this in 2 ways. One, first, in footnote 8 of Bearden, the court said actually the better framework to address this issue is not equal protection, because indigency is more of a spectrum. It's a relative term. A person, compared to you or I may be indigent, but compared to the next person is not. So really the question is a due process. The due process one. And they said, but both equal protection and due process are safeguarded by the trial court's exercise of discretion. Now, then I would point the court to...
Let me, and I'm sorry I'm just not hearing a good answer to my question, and I apologize if it's me not asking a good question. So would it, in your view, violate due process if one person gets to be on probation because he or she can pay for the treatment and somebody, is not permitted to be on probation because they can't?
No, and it wouldn't violate it. And I would point the court to State v. Morrow. It's a Minnesota case that I cited. And in that case, the court said it doesn't offend the Constitution to require a defendant who cannot afford treatment in the community to receive treatment in prison.
Okay, and I don't remember the case. Can you help me with the rationale for that? What was the basis for that?
I'm sorry, were the facts for
No. Tell me, so that was the conclusion. What was the analysis? Why doesn't it offend the Constitution?
Well, I think one of the reasons is there's a rational basis for doing that. Because if a defendant can't receive treatment in the community, if he can't afford it, and the court has deemed that treatment is necessary to protect the community, then there's a rational basis to require him to receive that treatment in prison. So I mean, just because there's a distinction made between a defendant who can't afford it, treatment in the community, and a defendant who can't, doesn't mean that there's an equal protection violation. Morrow talks about, equal protection deals with the lines drawn by the legislature. The legislature draws lines all the time. The question is whether there was a rational basis to draw the line where it did. Here it is, because the other option, and I know again, there might have been this voucher option and this argument that the defendant, or it's cheaper to treat the defendant out in the community than it is in prison. Even if that's true, I think the law doesn't require the government to have to accept that option.
What's your response to your opponent's argument that the alternative here would have been to have the state pay for the treatment?
Well, there was testimony by the probation officer saying that their funds were limited. You know, they have to divide up these vouchers amongst all their clients. There's a limited there's limited funds. And I'm not sure, I mean, maybe it does cost $111 to house someone in prison. But I'm not sure the court has the authority to I guess, order the Department of Corrections to reappropriate those funds or transfer those funds to the probation department, or order the probation department to send the Department of Corrections a bill for that amount. I mean, those are separate funds, and I think there would be, again, I think it's going tomorrow again. There would be a separation of powers issue if we did allow the court to do it. But again, even if that was possible, I think the question here is, was the court required to do it? Did something in the law require the court to do it? And I don't think there is anything in the law that requires the court to do that.
So, Mr. Olivares, let me just ask you about how many of these cases deal with a regulatory scheme as comprehensive as what we have for sex offenders now? Because obviously the concern is that sex offender treatment and the scheme that surrounds them when they're on probation circumscribes their lives to a point where it almost seems like a recipe for failure. So some of the cases on which you're relying, Bearden, for example, is 35 years old. Do we have cases that are addressing this more modern kind of problem where it seems like they're placed in a box that doesn't allow them to succeed?
Yeah, and I think if you look at my analysis on the abuse of discretion, even though abuse of discretion wasn't really included, I cited a number of cases, about 7 or 8 cases, that all deal with the revocation of probation for failure to complete sex offender treatment, and really where the court's addressing this Bearden issue or this ability to pay. And you have to remember that in the legislative declaration of SOISP, it says by placing someone on sex offender treatment, it doesn't say that they are going to succeed on it.
Right.
But it gives them the chance. And the defendant here had 3 chances, and he failed every time. And so at that point, what's the court supposed to do?
Because of the public safety issue.
Because of the public safety. I mean, it was at its discretion. And it should have that discretion. It should be, what we don't want to do is limit the court's discretion and say, you know, under these set of circumstances, you are required to continue this person on probation, even though they may go untreated, even though they may be unmonitored. And those are the purposes of SOISP. To identify, evaluate, treat, monitor, manage sex offenders. And that wasn't happening here.
Can you remind me quickly where I would find those cases in the answer brief? Or if it's going to take you time, don't worry about it.
No, it's just in my, it's the abuse of discretion section.
Okay.
And there's a number of cases. Pretty much every out-of-state case I cited deals with that, and it is within the last 10 or 15 years. And it really, you know, as Mr. Jackal pointed out in his reply brief, you know, the SYSP and these programs are really a creature of the early 90s, and I think that's when you start seeing these cases pop up.
I'm with you. It looks like page 26.
So even if for some reason the trial court here was required to determine if the statutory exception applied to the defendant, it properly found that the defendant's violations were not excused by the circumstances. Under the statutory exception, the defendant's failure to pay shall constitute prima facie evidence. And I don't think there's any argument that the term...
Counsel, sorry.
Please.
You keep referring to the statutory exception, and I understand the way that the listing in the statute creates an exception, sort of, but the argument that your opposing counsel is making is not that the statutory exception should apply, it's that due process requires this consideration.
Of course, and the issue there, and why I'm actually hesitant to even talk about what test the court should have applied to determine willfulness, is because I think that's the only place that you can find an exception, a requirement for the court to look further into willfulness, because again, Bearden's satisfied. So there's no due process violation. So any further inquiry the court would have to make would be under the statute. So that's why I'm talking about the statutory exception. I'd be happy not to talk about it, but it was part of the cert question, and I can go forward and talk about why I think a Fentel, if this court does reach the question, which I don't think it should today, but if it does, why it should affirm a Fentel's burden-shifting procedure.
I haven't read this in a long time. Wasn't Affentool like a deferred sentencing, and whether the guy could be revoked or even had to be turned loose as having fully complied, whether he could pay or not?
Yes, it was. But the language from that case, from the deferred judgment statute, is exactly the same, and it was also created in 1983 as the language in the probation revocation statute. And the Supreme Court in that case actually, linked it to, made some comparison to probation revocation hearing. So that's why I think the courts in Roletto relied on a Fentel to not only, adopt this burden-shifting procedure to probation revocation hearings, but also expand it to create a totality of the circumstances test. Because the test that comes out of Romero and Strickland, it's this three-part test that the prosecution must prove. And that's a very rigid test. That's almost like, it's elements that the prosecution has to prove. And again, placing the burden on the prosecution it makes more sense to place the burden on the defendant, because it places the burden of showing, inability to pay on the party that is in the best position has the greatest access to that evidence. In fact, the defendant might not even know that the defendant is going to assert the defense until the revocation hearing. And it also ensures that the trial court's ultimate determination is based on accurate findings of fact. And as I said earlier, that's really the purpose of revocation hearings, as stated in Byrd. The purpose is to allow a sentencing court to fully consider the defendant's conduct and determine whether or not the original sentence is still appropriate. This is unlike a criminal trial, where the purpose is to determine if the prosecution has met its burden of proof. And then again, finally, in resolving any ambiguity in favor of a narrow construction of the exception, this court will be avoiding imposing rigid requirements on the probation revocation hearing and interfering with the discretion of the sentencing court.
May I ask you, if, as a matter of due process, you've talked about the court's discretion, if the defendant raises inability to pay as a reason in a case like this, is the court required to consider that, the inability to pay?
As a matter of due process, the court is required to hear any arguments from the defendant. And Morrissey and Gagnon say that. It's required to accept evidence from the defendant. The defendant has a right to testify on his behalf. He has a right to make arguments that his conduct was somehow justified or mitigated. The court's not required to accept that, and the sentencing statute still allows for revocation, even if that evidence due process still allows for revocation, even if that evidence is somehow credible.
All right, so, and I know your time's up. If the sole reason is inability to pay, there is nothing else, due process allows revocation?
As long as the court exercises discretion.
Okay, thank you.
Thank you.
Thank you.
Well, thank you. I'm glad he left off on that point, because I'm afraid counsel has misstated the holding of Bearden. I know it's the holding because the paragraph
Could you
starts
stay near
with-
the mic, Mr. Jekyll? I'm having trouble
yes,
hearing
I'm
you.
sorry. I believe counsel has misstated the holding in Bearden. I know it's the holding because it starts out the paragraph by saying, "We hold therefore." So Bearden requires the court first to inquire into the reasons for the failure to pay, and it can revoke if it finds that he willfully refused to pay or failed to make sufficient bona fide efforts to get the resources to pay. Then there is an additional requirement, and it's not just that the court has to consider alternatives. I think Justice Samora was getting at this. It's not just the court has to consider alternatives to alternative measures of punishment other than incarceration. However, the court must make a finding, and I'm quoting from Bearden here, only if alternative measures are not adequate to meet the state's interest in punishment and deterrence, or here we could substitute penological interest. Only if the alternative measures are not adequate can the court imprison the probationer. To do so otherwise would deprive the probationer of his conditional freedom simply because, through no fault of his own, he cannot pay the fine. Such a deprivation would be contrary to the fundamental fairness provided by the Fourth Amendment. So it's not just the court gets to think about, well, can we do something else here? The court must do something else, and only if something else is not available. Here, clearly, it's available. Mr. Sharrow is going to have to do treatment one way or other. He's going to have to do treatment whether he's in prison. He's going to have to do treatment whether he's in the community. The probation officer, and I wish the court would take a look at the precipitous nature of how he was taken into custody here. They're in the process of looking for vouchers, looking for ways that he can do this treatment, do the therapy and the group sessions that are required. And in the midst of that, he's taken into custody. 4 days later, he's kicked out of sex offender treatment. One other point, I guess I just don't understand when the state refers to the statute as creating an exception. I think it's blending the statute and Affentol, or the holding in Affentol. It's not an exception. It just is a simple procedural change that prima facie evidence of non-payment, is prima facie evidence of a violation. It doesn't shift the burden. It doesn't say anything about the standard for determining ability to pay. The burden of persuasion still lies with the prosecution. And the state shouldn't be able to make an end run around the due process requirements by simply pointing to the fact that he's kicked out of sex offender treatment. It has to inquire into the reasons. Thank you.
Thank you. Appreciate the arguments of both counsel. Case will stand submitted, and the court's going to take a 15-minute recess.
All rise. Court is in recess until 2:18. All rise. The court is in session.
Please be seated. So the next case on our docket looks like Kutzly versus People. We've scheduled this one for an hour argument as well. You all look ready, you know the equipment and the drill. Please, counsel for petitioner, as soon as you're ready.
Good afternoon. Tracy Renner, registration number 27242, appearing on behalf of the petitioner, Mr. Kutzly. As this court made clear in People v. Schreck and last week in Rubal v. People, the admissibility of expert testimony is governed by CRE 702 and 403, and the trial court's gatekeeping function with respect to expert testimony requires the court to make specific findings on the record about the reliability and relevance of the testimony in question, as well as findings pursuant to CRE 403. First, I'd like to talk about Rubal and why Mr. Kutzly's case should be reversed because the trial court here failed to make sufficient findings. And second, I'd like to talk about the misperception that reliability of this type of testimony, that there are commonly seen behaviors in sexually abused children and sexual offenders, used as it was in this case as evidence of substantive guilt, is well recognized. So first, in Rubal, this court reaffirmed that a trial court must make specific findings as to reliability and relevance. The trial court here made no specific findings about the testimony that Mr. Christensen would be offering, why it was reliable, and how that testimony was relevant to any particular issue in this case. First, the court found that Mr. Christensen had been qualified to testify in several cases before, but that was not a sufficient finding about the reliability of the testimony that he was going to give. It may have been a finding as to his qualifications, that he'd been qualified before in other courts, but it certainly wasn't a finding about reliability of this type of testimony. The court found, I'm finding it would be relevant under Rule 402, but the court made no finding about the specific testimony that Mr. Christensen was going to offer and the specific relevance in this case, what facts in this case were at issue that his testimony was necessary and helpful to the jury to explain. And then the court found that any question about the scientific foundation is a subject for cross-examination. And again, that's not a finding that that sort of testimony was reliable. And the court has to first make that finding of reliability before the testimony can be admitted. Then the court said it incorporated the case law cited by the prosecution, stating, I'm finding that this issue on Shrek has been resolved by Colorado case law, and I'm being asked to, in effect, overrule precedent because it has been examined with the detail that has been argued by defense. And to that, I would say absolutely that's not true. And that's my argument about, goes right into the misperception that this type of testimony has been generally admitted about behaviors of sexually abused children and about sexual offenders. And I think if you trace the case law through, it's almost like a game of telephone where courts have admitted this type of testimony or affirmed the admission of this type of testimony for reasons not about the reliability of that testimony, but either affirmed that it was not testimony offered for the truthfulness of the child in question or some question about the helpfulness of the testimony. But it has over the years become this misperception that this type of testimony is generally reliable. And in fact, that's what the Court of Appeals said here in making its ruling, is that essentially expert testimony about general behavior of sexual assault victims is admissible, citing Whitman and Glasser. which are Court of Appeals opinions. Whitman is from 2007 and Glasser is from 2011. Both Whitman and Glasser, though, rely on cases, none of which address the reliability of this type of testimony. They discuss other types of testimony about behavior of sexual assault victims in other contexts, but not this type of testimony that was offered in this case. And I might add, offered in this case as substantive evidence of guilt. It was used offensively by the prosecution in this case, and it was also argued in closing as substantive evidence of guilt. This was not offered to address any sort of puzzling behaviors of the child, and the trial court didn't make any specific findings that this testimony was going to be relevant to some particular issue in this case, and that it was necessary and helpful to the jury in this case.
Could I ask you, since you started off with emphasizing the requirement for findings that we've done, if I understand you're saying this has never been approved as relevant, as reliable by an appellate court. But if it had been in this jurisdiction, would the trial court have had to make findings with regard to the reliability of that?
Well, and I think what the court said in Rubal is, and I believe in Schreck as well, is that if the testimony itself is well recognized, that perhaps the court doesn't need to hold a hearing. But I think if there is some question, as there was here, and if there is an objection and a request to put on evidence or some new social science research perhaps, the fact that it's been admitted before in other cases does not make it reliable, especially 20 years later.
But I think the Chief's question goes to findings as opposed to hearing, and I had the same question. So what happens if I'm a trial court judge, and this happened to me when I was on the trial court bench a lot, and there's proposed testimony, and there appears to be case law that has said in the past that it's admissible, that it's sufficiently reliable. In that case, does the court still have to make a finding, separate and apart to whether you have to have a hearing or not?
Well, I guess I think what you're getting at is the Court of Appeals here had some, the trial court here had some Court of Appeals cases that it was relying upon in saying, I don't need to make any findings of reliability because this has already been admitted. And my position on that is that if the court had looked really closely at those cases, it would have found that testimony, and tracing it back, that testimony had not been found to be generally reliable and well recognized. And so I think the court does need to make findings when there is a specific objection and there is other evidence presented or questioning the fact that perhaps this has been admitted in cases over the years, but now, we know that there really is no identifiable behavior that would identify a child as having been sexually assaulted, and so there has been no consensus in the social science research about that. And so I guess my point is when there is a specific objection and an argument that despite the fact it's been admitted all these years, this court should take a closer look and a specific record has been made that the court can't just rubber stamp, well, it's been admitted previously. The court should make some additional findings. And I guess that, the evolution of the law in this court, much of it that's relied upon in the Court of Appeals is pre-Schreck. Pre-Schreck, where the requirement of reliability in the application of CRE 702 was outlined in greater detail. A lot of the cases rely on Hampton v. People, which was a 1987 case that talked about the reaction of sex assault victims, countering the lay notions at the time, and it was not, and the court specifically noted it was not used to establish a crime was committed, and that's certainly not the case here. This evidence was clearly used almost as a template for the prosecution argued, a template that you could overlay the facts in this case, see if it matched up, And, based on what Mr. Christensen said, we know what sexual offenders look like. We know what sexually abused children look like. The facts of this case fit that to a T. We've learned a lot from Mr. Christensen about what sex offenders look like and sexually abused children. Let's talk about what we've learned. That's grooming, that's delayed reporting. That's all the things that Mr. Christensen talked about here, a lot of which also addressed some specific facts in this case. And so it was argued as substantive evidence of guilt in this case.
Ms. Renner, can I ask, if we were to rule in your favor and kind of lay out a roadmap for how this should be conducted, what are our steps?
Well, the first step, in my mind, is that the court needs to make some comment on the prior line of cases, and that.
Do we have a pretrial hearing, or is that done
I'm sorry, you're
at
talking about in the
trial?
trial court.
Yeah, right.
Well, I mean, whether the court conducts a hearing, I think does go back to the standard that's already been articulated in Schreck and Rector and in Rubal, as well as if there is a specific objection, if there is
There's always an objection, right?
Well, but I guess the question of whether the subject of expert testimony is well recognized may be subject to dispute. And in my opinion, in this case, the court should have looked a little more closely at the cases that existed.
So what would be the test for whether there's a pretrial hearing? Can't just be if there's an objection. I mean, that's kind of what was part.
I guess I thought that's already been decided, that if there has to be a specific objection and specifically what the testimony is that you're objecting to and why it's not relevant in this particular case and that sort of thing.
Well, that's what I'm asking. What would you say so that we know, because I will say there was always, again, echoing Justice some more, always a little bit of debate on the trial court as to when we needed to do a pretrial hearing. Was it every expert? What was it? So if we're going to lay out a roadmap, I'd like that to be clear. I'd like that gift for the trial court.
Well, and I think that it is when, I guess I don't know how else to say it, when there has been, when it's been brought to the court's attention and that there's some reason to question the reliability of this particular type of evidence or the relevance in this particular case. I mean, the court can also there has to be a motion filed or some objection motion to the expert's testimony, and it has to be specific as to the aspects of the testimony that either the litigant is arguing is not reliable or that it is not helpful to the jury in this particular case because that particular aspect of the expert's testimony is just not implicated in this case.
So, for example, what would you have said in the motion questioning the reliability? What is laid out there? You can't just say the testimony isn't reliable, because then it swallows the...
Well, I think you'd have to say why.
Right. Well, so I'm asking, why would you in this case, how would you articulate that motion?
Well, I think it was well articulated in this motion. I think it was well articulated in the motion and at the hearing that just because this has been admitted previously doesn't mean that this court should rubber stamp it and allow Mr. Christensen to testify without making findings of reliability and without making findings of relevance. And defense counsel in this case, in the written motion, also went through aspects and attached a transcript of Mr. Christensen's testimony in a prior case and argued that that testimony was not reliable because it was generalizing based on his clinical experience to all children who may have been sexually, or all children who have been sexually abused and all offenders. So there was a pretty specific argument made in the motion by defense counsel here and at the hearing.
Okay, I'm not criticizing. I'm just trying to figure out a rule that I could, or that we could articulate to give a clear roadmap, so.
Can I ask the question a different way? Could you give an example of a time where an objection to an expert was made and you think a hearing wouldn't be necessary?
Well, if there's no contention that the subject matter of the expert testimony is not well recognized, if it's the testimony is going to, I mean, for example, an expert coming in to testify about serious bodily injury, and there is just no objection. I mean, that is not the defense at trial, whether serious bodily injury was present or not. And so you've got an expert that there's no objection about. But I guess you're.
Yeah, but I'm saying,
if
what
there-
would be a situation where you did have an objection, but it didn't trigger a hearing? Because it sounds to me like maybe you're saying anytime an objection is made, the court has to hold a pretrial hearing.
Well, and I thought this court in Rector talked about that it has to be a specific, the litigant has to identify the specific expert, the specific testimony by the expert, and the reasoning why it's not well recognized and why it's not. So I mean, it's always up to the trial court to decide whether or not to grant a hearing in a case. And I guess I just believe that that's been already addressed.
Let me take a boundary case here, just that going back to my beginning about
Okay.
if things had been established. If somebody was going to produce a fingerprint expert from the CBI or something, and the objection was, it's expert testimony, the reliability of fingerprints is in question. Would that require a hearing?
Well, and you're saying there was an objection that it's not reliable? Mm-hmm. I think there would have to be some showing on the part of the litigant as to why they're arguing that it's not well recognized. And I've actually seen that argument made, and it's in the motion, and they refer to the handbook, and there's some substance to the argument that even though this may have been admitted in other cases, that here are reasons, court, you should consider not finding that it's well recognized at this time.
So, and maybe if I could take one step further, so you think a hearing would be required unless, and do you even agree with this unless the court could say, no, those objections have been taken care of in appellate opinions before?
Well, again, I think that is what happened here to a certain extent, although the court held a hearing. I mean, I think a court can always say, and I'm finding that there are cases that have found this to be well recognized, therefore I'm denying your objection and we're moving forward, or I'm not going to grant a hearing. But I guess I do think that trial courts can't just rubber stamp, especially when there's been a long period of time, and there may be new studies or new research out there, if presented with that, not to take that into account and consider that question.
I guess it sort of begs the question of what it means for something to be well recognized, because it seems to me that, at least as we generally use the terms, you could have something that's both well recognized but still unreliable. Fingerprints recently may be an example in some people's opinion, because it's well recognized in the sense that I think most people consider it to be a very reliable form of evidence. But recently there's been some evidence, some studies to suggest that maybe it's not as reliable as we think it is. And so how do you define well recognized? Or have we defined it in Rector and elsewhere?
Well, I guess it's well recognized in the relevant field, and I think that probably goes back to Daubert and Kumho. That
Try even with that language.
well, it's I'm not saying generally accepted, but I think that that there are some principles underlying the expert's testimony that has some reliability, and yes. It's,
And I guess I'm trying to say, well, I recognize to the point that it obviates the need to have an evidentiary hearing. So I'm just trying to drill down on that and figure out what that really means.
well, and I think it depends on the discipline that you're talking about. And I think, in this particular context, my position is, and I don't think the state has provided any additional authority, that there is no behavioral characteristic that is indicative of a child being sexually abused. And so for an expert to talk about, I see these certain things in my practice, and to generalize them to being true of all children who've been sexually assaulted and all adults who might be offenders, that is it's expressing an opinion that these are indicators, these are guideposts that a jury can look to in deciding guilt in a case. And so there has to be some basis in the social science that is the case. And I don't think that is true here.
Let me, if I can push and maybe take you a little bit of a different direction, focus more on this case. Does it make a difference that Mr. Christensen here was a blind expert? And you've said you have trouble generalizing to all. Mr. Christensen saw 1,000, offenders and kids, or some large number. In terms of just, the court here started with, here's what Rule 702 says, quoted the language, and it talks about, would it be helpful to the jury, and is he qualified? And then the court went to relevance, which I have to say I read as really, would it help the jury? I think that's, in context, I felt like what he was saying, and he's qualified. Why isn't that enough here? To say, I've seen 1,000 offenders or 1,000 victims, and here are the characteristics that I see when I see these folks. That's just education for the jury. Why is that not reliable and at least an assistant would be of assistance to the jury?
Because it's really being put out there as a diagnostic tool. It's really being put out there.
Well, why? I mean, jurors might, an ordinary juror, for example, there's lots of case law that would suggest a very young child, the first time they have a forensic interview, they don't say anything. Then the second interview, they start talking, and when they feel more comfortable, they may get some details messed up, but they kind of get the core. Those are why do you need more than someone say, I've seen 1,000 kids in this situation, and these are things that I see very frequently. To let the jurors know why there's a delayed outcry or something, it just helps a juror understand something that they might not, what took 8 years for you to say something?
Well, I guess two things. One thing, I would point the court to the Henley case, the Supreme Court of Oregon, that talked about it's not how much it's not how this evidence is presented. Even if it's not meant to be presented as scientific evidence, it is perceived by a jury as having a scientific basis because the witness has degrees, because the witness has, in their clinical experience, seen so many different children.
There's an aura of scientific infallibility.
Perceived as scientific, and
Right.
it should be held to that same standard.
But there doesn't seem to be any question here that this doctor, this is not, some fly-by-night person, did SOMB evaluations, et cetera, had lengthy experience, and nobody seemed to question his qualifications. So I understand the court has to be a gatekeeper. Daubert said that, Schreck makes that clear. But I guess I'm just wondering where's the line? At some point it does go to weight as opposed to admissibility.
Well, I think it goes to relevance in 403. We can't mislead the jury with evidence that isn't reliable, but even if the court finds it's reliable, the court still must make specific findings that it's relevant to a particular issue in the case.
So where is the reliability problem here? This doctor has seen 1,000 kids, and here are the things I see. I conclude, I'm the court, I conclude this would be helpful to the jurors because this is stuff they may not know about. What more do you need?
Well, again, it's not just being used to help the jury understand some peculiar aspect of the, and I don't believe that delayed reporting was actually really an issue in this case. But it's being used as a sword and not a shield. It's being used as substantive evidence of guilt. It's not being used to rebut some argument that the defense was making that the child delayed reporting, and therefore it's not believable. The child's allegation is not believable. The fact that the expert in this case had seen so many, and I guess what he sees in treating and providing therapy to children and offenders is something different than the type of reliability that is necessary for a criminal conviction beyond a reasonable doubt. And the testimony that was being offered in this case was being offered as this is true of all children, not just what I see. And he didn't qualify it, at least until much later in his testimony. When he first began testifying, it is children who are sexually abused. This is common, this is common, this is common.
So I'm trying to understand exactly what the trial judge should have said in order for this to pass muster. So if the trial court had just, in maybe a fairly conclusory way, said, based on the evidence, I find that it's reliable, it's going to be helpful to this jury, and the probative value is not substantially outweighed by the danger of unfair prejudice, would that have been enough?
No, I think the court actually has, I guess I would analogize it to the 404B findings that the proponent of the evidence has to make a precise evidential hypothesis, and the court has to make specific findings in this case as to the relevance and to what facts in this case it's relevant to help explain to the jury something.
And I know you want to say for rebuttal, but I just wonder whether that doesn't sort of cut against Schreck when Schreck talks about how the trial court doesn't have to use specific factors that are laid out in Schreck. I mean, as I understand Schreck, it would allow the trial court not to even use any of those particular factors, maybe particularly in experience-based expertise cases where the case may not be as amenable to that kind of evaluation. So are you suggesting that the trial court really does have to go through those factors in evaluating reliability? And if not, what?
Through the factors of?
The Schreck factors.
Schreck factors.
Yeah.
Yes, I believe a court does need to go through.
Even though Schreck explicitly says that it doesn't, right?
Well, I mean, I think this court reiterated the court has to make findings of reliability and the court has to make findings of relevance. And it says specific. And so I guess that's where I'm going back to. It has to be specific, and I think it has to be specific to this case. So if I may reserve the remainder of my time for rebuttal.
Thank you.
Lee?
Thank you, and may it please the court. John Lee on behalf of the people, bar number 38141. CRE 702 requires relevance and reliability. Those inquiries are,
Please,
they
could you
look to.
pull the microphone down to that?
Those inquiries, is that better?
Yes.
Those inquiries look to and are guided by the actual opinions that are proffered. In this case, at every turn, the defendant's arguments are met with the same central burden. There's a disconnect between the opinions that are actually offered in this case and the way that they frame the opinions. The expert never testified that it was indicative of all child sex assault victims. His opinions were limited to what he had seen in his experience.
Let me stop you right there then. So I didn't go read the record. The representations in the defendant's brief seems to be counter to that. They seem to be a number of points saying that the expert said, sexually abused children do this, they do that, they typically do this. Is that not right in terms of the testimony?
What I believe they have in the brief is by implication, but yes, the testimony is in his experience. The questions all begin with, and their sets of questions begin with, in his experience, and then they go down through, and he's describing what he's seen to be consistent in his experience treating both adult sexual offenders and victims of child sex assault. So I think whenever we're looking at a 702 issue, the question of both reliability and relevance is always going to turn on what the actual opinion was offered, because that's kind of what dictates whether or not the grounds and the ultimate opinion are relevant. There's a lot going on in this case because I think it presents the questions of whether or not sufficient findings were made in this case, and in general, in more broader terms, what do we do with experience-based testimony, and when does a trial court need to hold a hearing? So I guess how I would like to proceed in this case, just kind of given how the first part went, is I guess I disagree that the trial court made insufficient findings of reliability. I think it did. I'd like to discuss when a trial court does and does not need to hold a hearing, what the test actually should be, should this court decide to add and clarify what it's previously said, and then why that test was amply met in this case, both based on what the trial court found and also what we know given the record that we have. So as for whether or not the trial court made sufficient reliability findings, I would point to 5 aspects of the trial court's oral ruling and also make one additional legal point. The trial court made its oral ruling on December 3rd, 2010, and it's a 4-page ruling starting on page 40. So it's not a quick summary, just it's admissible. The trial court did make findings. The very first thing I'd like to point to is the trial court began by saying that both parties agreed that Christensen, given this exact testimony, had been qualified in other trials before. One of those was the Escobar case, which was included along with the defendant's motion, where you have the full transcript of his testimony. That finding incorporates the previous finding of reliability and relevance, where, again, in the Escobar case, he sets forth all of his training, qualifications, and experience. So although not explicit, I think that initial finding by the trial court was essentially an incorporation of the findings in Escobar. The second one is, and as this court found in Ramirez, and I think Justice Gabriel's question got a little bit at this as well, reliability and relevance are interrelated. Whether or not something is reliable, the ultimate opinion is reliable based on the grounds, is another way of saying is whether or not it's ultimately relevant and not unduly prejudicial. In this case, the trial court, by expressly limiting what type of opinion it would allow, because here it said it would allow him to testify about the common characteristics, but would not allow Christensen to testify as to an ultimate diagnosis, showed the court that's an actual exercise of its discretion and a reliability finding, that although his testimony and the reliability of his experience was sufficient to testify about common characteristics, the trial court found that it would not allow it as to an ultimate diagnosis. So I think that's yet another reliability finding. The third is the trial court likened this case to cases of consistent physical injuries and sexual trauma cases, which again I think is just another example of the trial court saying that this is like that case. Just like how it's reliable in those cases, it's reliable here. The trial court also cited the Ramirez case and pointed out that in that case, the nurse had testified based on 91 different examinations. In this case, as the record before the court shown, he had treated over hundreds of children's sex assault victims and even more sexual offenders. So that's just another exercise of the trial court's discretion. And finally, the trial court pointed to the case law that the people had cited, which showed that this type of testimony was reliable. And as those cases ultimately held that this kind of testimony was admissible under 702, that, again, is just a reliability finding. It's incorporating the appellate court's findings that this testimony should be admitted.
Can I ask a question there then? So if all he was doing was testifying about the breakdown of his own sample, the people he had dealt with, I've interviewed 500 sexually assaulted children and 400 of them did this, whatever. And what is it that's reliable about that? I mean, that may be true, and he may have, that's exactly what he said, and so that maybe is reliable. But are we to infer something from that is reliable? Is there a principle here, whether we call it science or statistics or whatever, that leads to a reliable conclusion from that? Or are we just saying it's worthwhile in itself that he's had this experience with 500 kids or whatever?
Yeah, I think there's a couple of ways to answer that. As far as the trial court relying on appellate case law, I think it's the appellate court's finding that the testimony is reliable, that the experience and the behavioral science is in itself a reliable basis for the opinion. If we were to look at this more broadly as to what is reliability, I think the best example we have in case law is the General Electric v. Joyner thing, that the U.S. Supreme Court case, where they said something's not reliable if there is too wide of an analytical gap between the grounds and the opinion. So when we're looking at reliability, we're looking about whether there's a reasonable nexus between the grounds for the opinion and the actual opinion that's offered. So in the context of this case, where someone is offering something based on their extensive experience, so long as the experience is reliable, or there's a sufficient number of that experience tethered to that opinion, then it is sufficiently reliable. So to return to the question of when should a trial court hold a hearing or not hold a hearing, I think there's, at least from this case, it shows us two instances where a trial court would not need to hold a hearing. One would be when there is well-founded case law setting forth that the type of testimony is reliable. In those cases, I think absent something new and compelling, a trial court doesn't have to hold a hearing. An example would be DNA. If defense counsel said DNA evidence is going to be admitted and DNA just sounds fishy to me, I don't think that's sufficient to hold a hearing. If there was something new or something that actually reasonably called into question the basis of the prior opinion, then maybe the trial court should hold a hearing. But absent an actual challenge, I think Rector gets close to this, and that's really along with its purpose, then the trial court can rely on previous case law finding evidence to be reliable. I think the same principle applies even when there isn't case law, but when there's not actually, when the trial court can tell based on what's before it that there's really no reasonable attack on the evidence.
What constitutes a reasonable attack? So we talked about fingerprints earlier, right? A lot of case law out there that says fingerprints are fine, right? But more recently, we've seen study from well-respected forensic institutions saying, well, maybe not so much. So does that mean we need to have an evidentiary hearing every time fingerprint evidence is going to be used if there's a specific objection made?
Well, in the fingerprint context, for that given example, I think that would be a discretionary decision when you have case law going both ways. I think a trial court could hold a hearing, wouldn't have to. When it should hold a hearing, I guess I'll give an alternative example, Wilkerson. This court's Wilkerson case. I think that's a good example of where a hearing was necessary. That involved an ergonomics expert who testified that wanted to testify that based on his knowledge of ergonomics, he thought it was a 51% chance that the pulling of the gun was accidental. There's absolutely no basis for that opinion in the record. An objection to that, I think, would have required a reliability hearing because you would actually have to show the grounds for why it would be a reasonable conclusion, how ergonomics got him to that 51%. So it's when I think there is a colorable question regarding whether or not the opinion is based on reliable grounds. And absent that, then there's really no point for a trial court to hold a hearing.
All right. Thank you.
Was there an express finding of reliability in this case?
The ones I went through previously, I think those were, or at least they were tantamount to.
But did the court ever say, I'm finding this is reliable because, and give his explanations?
It never used the word reliable to my knowledge, but I think it is implicit within those 5 things I pointed out.
And is that something that you think should be required?
It's a court should make, in admitting the evidence, I think it necessarily makes a reliability finding, because 702 requires relevance and reliability. So it's certainly something, I think it can be something that is implicit, as it was here, and I think it was implicit in at least 5 ways. And I think this court, at least in Roybal and other cases, has been very clear that I don't think there's any magic words that need to be said. It would seem odd to me that if a trial court, as I think in this case did, necessarily made a number of reliability findings, although without using the word, that we would send it back just to say the word reliable. Particularly when there's case law, and I think in this case, given Rector, there's also the open issue of whether or not the court even needed to hold a hearing, whether the objection was sufficient to trigger a Shrek analysis at all. Given the generalness of the objection, it was really just challenging the case law. We're not really adding anything new. Just saying you can't, this type of science itself just isn't convincing enough to be admitted. So to take a step back and as to how this test actually should be for the purposes of guiding trial courts, I think it's as this court said in Ramirez, we look to our rules of evidence, and it's a simple three-part test. It's, is it relevant under 401? Is it reliable? And I think that looks at the general electric test. And I think to give it even more color, it's whether or not there is a reasonable and sufficient nexus between the grounds and the opinion, and then it's regular 403. That even if it meets the first two, is it still so unduly prejudicial and not so relevant that we should exclude it? So for example, in a case where it would be cumulative or it goes to an issue where it's not a disputed issue, the trial court might keep it out just because it's distracting. So I think those are the three factors that a trial court should consider when admitting this kind of evidence.
Can I ask you a question about the third of those? We sort of combined a 702 along with a 403 aspect in Shrek and talked about that. But we did seem to, and we seem to have since included the 403 aspect of that in the requirement that there be findings. Normally with a relevance determination, under 403, we wouldn't normally require that kind of a thing on the record. Do you think that was intentional, and how specific is it? Ms. Renner talked almost sort of by analogy to a 404B hearing. Do you think our rule with regard to experts requires then, if you do find reliability of the science and qualifications of the expert, that then you must go on and on the record put on some evidential hypothesis of why this is sufficiently probative not to be outweighed by the dangers of 403?
And I'd say no, I don't think it's required by the text of the rule, and certainly not by this court's cases. The rule is much more open than the federal rule. It is phrased, again, just pretty much relating it back to the other rules of evidence, and this court's cases have been in full accord. It's a regular discretionary decision by the trial court. It doesn't require express findings or consideration of specific factors. And again, I think especially with like a 403 finding, when you admit the evidence, the trial court is necessarily finding that's not excludable by 403. So I think it doesn't require an express finding. I say that a court should only consider it within making its decision, but I didn't mean to say that I think a court has to make an express 403 finding on the record. I think it does so when it decides to admit the evidence.
But actually, wasn't there an express finding under 403 here?
There is. I'm just saying I don't think to the extent the question was, would a court reversibly err in not making a 403 finding on the record, I don't think that's required. I mean, it's something that the court certainly can make. And as this case shows, it's something that normally comes up when you're dealing with these kind of cases because they're all intertwined. A 403 issue is, depending on what words you choose, it is kind of jumbled into the questions of relevance and reliability.
So if the trial court here had simply said motion in limine denied and nothing more, then you would say we're still fine because the record supported the bottom line.
Yes.
So from your same standpoint, Mr. Lee, is there anything that we haven't said in Shrek or Ramirez or Rector or even Ruibal recently that you think we need to clarify or that we need to develop?
Yes, I would say I'd ask for two things. One is the language in Shrek where it talks about it needs to be scientific, it has considered the scientific principles behind the test. And I think that's really where the briefing in this case goes, because if it has to be scientifically based, then it seems to suggest, well, then what is scientific? And that was kind of the argument below, that in order to be based on a scientific principle, it had to meet the scientific test, which included an error rate, which is something that this court's cases have repeatedly rejected, most recently and directly by Ford v. Eicher. So I think that's a problem, especially given Ven Alonzo, which I think is a just plain reading of Rule 702, which recognizes that expert evidence isn't just scientific evidence. It also can be based on specialized experience. So there are going to be certain instances where how we would look at scientific evidence is different than how we'd look at expert opinion evidence. And I think the Court of Appeals published cases post Ven Alonzo bear out that point. 3 cases have been issued where the Court of Appeals, post-Van Alonso, have found experience-based testimony that should have been admitted as expert, where it might have previously been lay. The first one is Jacquois, where the Court of Appeals opined that in a case dealing with a masked robber with a distinctive walk, that the officer's testimony, because he was sufficient, he was a hunter, and he had knowledge of tracking, that his description of the distinctive gait, because it was based on specialized experience, should have been admitted as expert testimony. But if we look at the Shrek factors and kind of what we generally view at, what we look at scientific evidence, I mean, those wouldn't apply to that kind of experience-based knowledge. I mean, there wouldn't be peer review on his personal history on hunting. People wouldn't have shared opinions or generally accepted view of how that suspect walks. The same is true with one of the other Court of Appeals cases, Bryant, where a police officer testified that the defendant said he had SHRM on him, which in that location was customary of being PCP. Again, there would not be academic literature saying SHRM is PCP. I mean, I Googled it and I was unable to find it, at least on the first 2 pages. But again, for that locality and based on his experience, that is what he knew, and it was based on his own specialized experience. So the same scientific factors wouldn't apply.
Could I take you back to the findings just a minute?
Sure.
Sort of playing over in my head, if I understood what you were saying about the basically lack of requirement for findings, because if the court admits this, then it obviously found it was reliable. And maybe I'm exaggerating what you said, but that sounds a lot like what happened in Ruibal by the Court of Appeals. And we seem to take the opposite position, that that wouldn't necessarily be sufficient, in part because of the plethora of considerations that could go into the balancing, for the very reason that there is not a specific set of factors, and the need to be able to have meaningful review of the way in which the trial judge exercised its discretion. Do you find Ruibal in that sense to draw into question anything you were saying with regard to the lack of specificity in findings?
So no, and let me, I guess, re-clarify what I was saying, and then I'll get into Ruibal. This court's cases have been clear, and I don't think there's any dispute about that reliability findings should be made. And I guess my only point is only when there's a colorable reliability question that's actually raised. So I would agree that as a matter of practice, a trial court should be instructed to make reliability findings. That's a different question than as to what do we do on appeal in terms of do we just automatically reverse if the findings aren't made. And I think Ruibal even supports my point on that position, which is if a trial court should have made findings but did not, if the record is nonetheless sufficient, a reviewing court can affirm. And I think that's true in Ruibal because the court, rather than just reversing, went to great lengths to point out that there was nothing in the record to support it, and even went beyond the record and found that no out-of-state case law supported the reliability of overkill testimony. So, I mean, I think Ruibal is a good example of what happens when a trial court should have made findings but did not, which means we don't automatically reverse if there's support in the record or in case law. And I'd say in this case, we have findings, and beyond that, it's completely supported by the record, and we have case law supporting it. So even under the Ruibal standard, even if we get there, because factually I don't think we do, this case should be affirmed.
Could I follow that up with just one question? Make a fairly fine distinction here, but I think it's played into the things that both of you have said. Do you think there is a difference between sufficient findings based on acceptance in other cases, whatever in the area, and yet nevertheless that it could be unreliable? That is, a trial court might be sufficient in making a finding to say this has been found to be reliable in cases A, B, C, and D, and yet nevertheless A, B, C, and D could be wrong, and therefore, although there was a sufficient finding, nevertheless the determination was wrong.
Yeah,
No, go ahead.
I mean, certainly a possibility that case law could be wrong. I mean, that's why we have appellate review courts. But as a practical matter, the only way I think this works is you have to raise a colorable challenge to that case law. I mean, it's not enough, and as in this case, just to be like, those cases are wrong. Why? Because they are. I mean, if you're going to challenge DNA, there needs to be a better challenge other than, we think there might be a problem there. If you raise a colorable challenge to the case law, actually undermining the reliability findings in those cases, then a trial court probably should hold a hearing and determine whether or not it is reliable. The problem in this case is no such challenge was raised. And then to finish up on Justice, oh, sorry.
It also depends on what the case law says, though, right? Because there could be, I think this was one of the points that Ms. Renner was making, is that sometimes the case law could talk about something having been admitted and focus on relevance and not really get into reliability specifically or in any detail, right? In that kind of case, is it appropriate for a judge to just say, well, this was admitted in this particular Court of Appeals case, and so I'm going to find that it's admissible here, right? So doesn't it in part depend on what the case law is?
I mean, it can, but I guess I would use this case as an example because I guess that's the best example I have. In this case, again, we not only have the direct case law saying this kind of testimony is admissible, but the prosecutor pointed out and the trial court pointed to, I mean, a long history of this kind of behavioral science testimony being admissible. A clinician working with a group of people detailing just common characteristics is without more reliable. So, I mean, certainly if there's the possibility that there is a thin case, maybe the challenge to that case alone could be enough for a trial court in discretion trigger hearing. I don't necessarily know if it'd be an abuse of discretion for a trial court to say to follow a case that it's required to follow. Because again, the trial court is in that position because a 702 ruling just really has those two components, relevance and reliability. So if it affirms it, it's implicitly, if not explicitly, finding both. So I mean, I think absent a more specific challenge, I don't think a trial court would err in relying on case law that's bound by. And to finish up on your other question as to the second thing I would like this court to clarify, beyond just saying that there is no, because it has previously said there is no immutable set of factors, I'd like it to go further and say that certain factors alone are sufficient to find testimony reliable in a given case. I think it's possible, and I think if we look at this case, there are a number of factors that show that it is. One would be, as the Fugger case we cited from Indiana, which I think is on page 43 of my answer brief, is if it's based on a direct science and they're not challenging the science, then that's enough. In that case, it was a simple opinion based on mechanical engineering. The Indiana court found that just a challenge to mechanical engineering alone was not sufficient to justify an inquiry because that field is reliable in itself, that is sufficient enough to find that the opinion was reliable. Another ground would be that experience alone is enough, as it was in this case. And I think the cases we cited for this were Brown, which is a Tennessee case, which dealt with a forklift case, saying that there are going to be some instances where the expert opinion is so based on such specialized experience that the experience alone can be sufficient to make it reliable. In that case, it was a forklift operator who had a number of patents in forklifts. So there wasn't the same kind of pure research, but the fact that he was such an expert in that field that it itself rendered it reliable. And of course, the Hernandez case was dealing with almost exactly what we have here, which is just saying that someone who has worked with so many children of sex assault for so long and is going to limit their opinion just to common characteristics, that's just reliable. I mean, because there is no jump between the opinion and the grounds. It was a simple, I've talked to this many children, and this is what I observed. I mean, that is a reliable basis. It's empirical. So when the testimony it's expert because it's experience-based, but it is strictly empirical, I think that's reliable enough. You don't need to do further findings. That's sufficient. So I think...
So in your example, though, I assume you're talking about a blind expert that then doesn't try to extrapolate those observations to the case at hand. If you instead had an expert that purported to actually extrapolate, is your answer the same?
That it would depend on I think it would depend on I would agree that it is always a shifting scale depending on the opinion and the grounds. So the more aggressive the opinion, probably the more grounds that you need. But I guess in this specific context, and I guess I'll use an example that defense counsel used, which is with child sexual assault syndrome, which actually involves a diagnosis, which they argue that I think 3 states have found it to be inadmissible: Kentucky, Louisiana, and New Jersey. But as the case they put in their most recent supplemental authority, JLG, the New Jersey case, it actually identifies that 40 other states and plus the District of Columbia have found it to be admissible, based just on clinicians' experience. So although I think you would need more, the broader the opinion or the more aggressive the opinion, I think you might need more grounds. In this case, I think we're fortunate in that his opinion is extremely tethered to just what he saw. They certainly argue that it implied more, but his opinion was always through the lens of what's your experience, and then it went through each, and then it returned again eventually to in your experience. That it didn't raise those issues.
Well, it's empirical can't be a complete answer, right? Because the data set might be so small that the extrapolation's just not warranted. So if, this guy had seen 10 people, 10 kids, 10 adult offenders and made some of the same conclusions, I think most people would look at that and say, well, that doesn't seem reliable because there's not much of a basis for meaningful extrapolation. So you agree with that?
I would disagree with where we put that. So I would agree. So for example, if he said, it's common in my experience, I saw 4 kids, that 3 kids said this,
Yeah.
that's not an unreliable opinion. I mean, it is reliable. I think you keep that out if you want to under 403, just because it doesn't add much. I mean, his opinion is reliable on the grounds.
I see what you're saying.
But in this case, again, we don't have that problem because he saw hundreds of kids and
I
hundreds of
understand.
sex offenders.
But then still, the distinguishing, maybe along the lines of Justice Marcus's question, between the sort of inferential aspect of statistics and simply the comparative aspect. So he might be able to say, and so 80% of the people that I have seen did thus and so. But he would, I presume even you would agree, he wouldn't be qualified to say, and therefore 80% of sex offenders do thus and so.
I mean, I think it would depend on the volume. His experience might be so representative because we have so many that I think it's possible that it would be enough to say that. I mean, it's certainly with a data set of 4, maybe not. If you had thousands,
I think in a few cases, like the older DNA cases, and maybe we've said it since, maybe Wilkerson to some extent, we've emphasized there may be 2 expertises involved here. One with regard to whatever the test is going on, whether it's a comparison or whatever, and another with regard to an expression of the results and the effect of that inferentially. I don't think there's anything here to suggest he had any expertise to be able to infer something from his experiences, was there?
I guess as far as this case comes to the court, again, it was limited to common characteristics. He did not actually offer a profile, which would require 2 things which aren't present here: that it is a profile, and 2, that the defendant met it. Neither were here. So whether or not there were sufficient grounds, I mean, I think arguably he maybe has enough experience, but I guess because we didn't get the testimony, we don't have a full record of it. So I guess, and just to finish off briefly, to the extent they argue that this is improper profile testimony, again, it wasn't. This court cases say that this kind of testimony is not profile. He wasn't actually he never claimed it was a profile. And I think it's a misreading of Salcedo to say that profile evidence is just never admissible. The problem in Salcedo was that the profile wasn't reliable. This court actually, I think, found that had he been able to actually show that the drug courier profile actually was tethered to what he believed, which are very things that apply to everyone: blue jeans, no watch. May I finish?
Please.
Got nervous on a plane, doesn't bring anything on that applied to everyone. So the problem was that it was a false profile, not that you could never provide profile evidence at all. I'd ask you to affirm. Thank you.
Thank you. Ms. Brenner?
I guess first I would like to go back to Rubal, where this court did say that the specific findings requirement is not satisfied by an inference And I may be misremembering, but I believe if a court says, if the court said here that it was making findings under 403, it was very cursory, and it was nothing more than its finding on relevance that I'm finding it would be relevant under Rule 402. So my position is still that the findings here are not sufficient, and that the court cannot, that the findings here are not satisfied by an inference that the court applied, that the court made specific findings and just didn't say what they were. I guess in terms of the reliability question, I would ask this court to look back at its case Stevens from 1990, where the court identified, it talked about there are certain behavioral changes associated with abuse, but acknowledged that there was still data being collected on that. And that case was only looking at that type of evidence for corroboration, for hearsay, and whether that was sufficient to satisfy 1325-129, not whether it was admissible as expert testimony as substantive guilt in the trial. So I think from that time forward, there has not been any change in the data, that there is not, that there are not certain behavioral changes that are associated with abuse that can be used as a diagnostic tool. And so it is misleading to the jury to be presenting this type of testimony as being common, that the jury then uses to compare to the facts in the case and render a guilty verdict. And that is what happened here. I understand that, Mr. Christensen was testifying based on his experience, and there were times where he qualified that as such, but most of the time he was talking about this is typical, this is common, and I can only, and again, I would point the court to the Oregon case where this is perceived by juries as being scientifically based, that there must be some studies behind this. It's not just, what he's seeing in his clinical practice. So I guess my position is I would ask the court to look at that reliability and if the court does go forward and find that there are sufficient findings here under Rubal, but then look at the reliability of this type of testimony, because I think there has been a disconnect in the case law as it's gone on through the years. And I would ask the court to reverse the decision of the Court of Appeals and reverse Mr. Kutzly's convictions for a new trial.
Thank you very much. We appreciate the arguments of both counsel. Case will stand submitted, and we will be in recess until the next set of arguments.